Rodney Hinton Jr. So there's some updates in regards to his situation. I believe he had a court appearance. Let's check this out.
Rodney Hinton Jr. walks into court with a bit of a smirk as he stands accused of intentionally hitting a sheriff's deputy with his car a day after his son was shot and killed by a Cincinnati police officer.
I wouldn't say he's fully competent, but as the days go on, I think he gets more competent every day.
I have the latest on Rodney Hinton's case and how his mental state will take center stage as he faces a possible death sentence for the murder of a sheriff's deputy. I'm Anjanette Levy, and this is Crime Fix. Before we get into the very latest on Rodney Hinton Jr.'s case, I want to tell you about some law and crime news and merch. The Law and Crime Docket is your one-stop shop for trending stories, thrilling body. Scanning the QR code you see here, it's time since a grand jury indicted him on aggravated murder charges for the death of a sheriff's deputy in Cincinnati. I'll get to that court appearance very, very shortly. The grand jury indicted Hinton on aggravated murder and other charges that include death specifications, meaning Hinton could face a possible death sentence if he's convicted of murdering Deputy Larry Henderson. It was Friday, May 2nd, when police say Rodney Hinton Jr. purposely drove his vehicle into Sheriff's Deputy Henderson, who was directing traffic at the University of Cincinnati's graduation ceremony. Henderson was standing on a concrete area near a traffic light. Hinton was in a median in his car when the prosecutor says Hinton stopped and drove directly into Henderson. Now, why would Rodney Hinton do something like this? No one can say for certain, but a day earlier, Hinton's 18-year-old son, Ryan Hinton Jr., was shot and killed by a Cincinnati police officer. Police say Ryan Hinton was armed and in a stolen car with friends.
This is the other officer, the one who fires the shot. This is his body camera as he approaches the scene. This is the firearm that was recovered at the scene after the individual was shot. This is what he had in his hand while the officers were chasing him. It's just a photo of it here at Criminalistics. Remember I told you he fell on the concrete and the officer said that they heard the metal hit the ground? There are 3 spots on here where this gun has scratches on it. We believe those occurred when he hit the ground with the firearm.
I'll have more on the people who were with Ryan Hinton later on. Now, hours before that press conference, Cincinnati police met with Ryan Hinton's family, including his father, Rodney Hinton Jr. The prosecutor laid out a timeline. At 9:33 a.m. on Friday, May 2nd, Rodney Hinton arrived at the Cincinnati Police Department for a meeting. 18 minutes later, at 9:51 a.m., Hinton became upset and left. Then at 10:37 a.m., Rodney Hinton left the police department with family members in their car instead of his car. Now, after this, the prosecutor had said that Hinton's family took him to get something to eat, but he didn't want anything. So instead, he took a 30-minute nap. After that, at 12:41 p.m., Hinton's family took him back to the police department to pick up his car. At 12:44 p.m., the prosecutor says Hinton left the police department, but returned 5 minutes later and drove through the parking lot before leaving again 1 minute later at 12:50. 10 minutes later, the prosecutor said that Rodney Hinton Jr. ran his car intentionally into Larry Henderson.
He waits there. There's no place to turn. There's no signal there. He's just in that unused lane. Because he was up a little bit of a hill, he was at a higher elevation, and he could look down and see what was going on in front of him. And he could see Deputy Henderson working that traffic light. At 1:05 p.m., Hinton floors the vehicle, crossing into the opposing traffic lanes, and drives directly at Deputy Henderson and hitting him.
Prosecutor Connie Pillage said Rodney Hinton's family was in the car behind him and actually saw everything happen.
He never veers off course. He never slows down. While he was paused in that unused center lane, there was traffic coming. He didn't make his move until the oncoming traffic had cleared, and he had an open road ahead of him.
The world can be a really scary and unpredictable place, and that's where our partner and sponsor, Morgan.
Yeah, so details like that going into the public, of course, not good for Rodney. There's more new footage that we have yet to cover here on the channel, and I believe there's also court appearance footage that we're going to check out as well.
We're going to get you where you're going. Okay.
Can you stand up for me, sir? I'll put this around your waist. Are you able to stand on your own? Locked up here. Hey, use this hand to hold you. I'm gonna put this hand in cuff.
The next day, Hinton appeared in court for his first court appearance and muttered something about gone forever to the deputies. Now Rodney Hinton Jr. is appearing in court for the first time since the grand jury indicted him.
We're here today because Mr. Hinton has been indicted by the grand jury on the two counts of aggravated murder with death penalty specifications, 1 count of murder, a specialty felony, and 2 counts of felonious assault. Mr. Hinton, if you want to be represented by an attorney but cannot afford one, I will appoint 2 attorneys who are certified by the Ohio Supreme Court to handle death penalty cases. If you hire your own attorney, he or she does not need to be death penalty certified. You can hire 1, 2, or as many lawyers as you want or can afford. If you are indigent and need an attorney appointed, I will select 2 attorneys that are certified by the Ohio Supreme Court. It is my understanding, sir, that you wish to hire your own attorney and in fact that you have retained Mr. Bennett to represent you. Is that correct?
Yes.
Mr. Bennett, you are representing him. Isn't that correct? Okay, thank you so much.
Now, Rodney Hinton Jr. could get 2.
He's going to have the money, right? He's just been getting a lot of support and a lot of outreach. So I don't think that he's going to have a problem money-wise retaining counsel. And then on top of that, there's probably a lot of lawyers, whether from a discount, whether on pro bono, because of the profile of this type of case, would be willing to step in anyway. So, you know, I think we hear a lot of situations where people are just like, man, you're going to get railroaded or messed over real bad if you don't get yourself a good attorney. In Rodney Hinton Jr.'s situation, expect him to have good representation.
Public defenders, but his family has hired a well-known defense attorney in Cincinnati who has handled high-profile cases. Now back to the hearing.
Mr. Hinton, I need to go over some rights with you, okay? So the first and the second count of the indictment are aggravated murder, and it is what is called a special felony, and it carries with it the possibility of the death penalty, which may be imposed, making this what we call a capital murder case. Although a capital murder case is procedurally much more complicated, most of the rights you have in a death penalty case are the same as any other type of criminal matter. The aggravated murder charge is also accompanied by 1 specification, which we will talk about in just a minute, okay? You are presumed to be innocent, which means the state of Ohio has to prove that you are guilty if they can. They do this by calling witnesses to the stand and presenting evidence.
Judge Jody Lubers then went over how the trial could proceed with a jury or without one in a death penalty case.
You have the right to have this case heard by a jury of 12 people. They would hear and decide the evidence. All 12 must be convinced beyond a reasonable doubt of your guilt in this case in order for you to be convicted. If the jury finds you guilty of the crime and the specification, they can recommend the imposition of a death penalty. They can also recommend 1 of the life sentences options, which I will talk about in just a minute. In the alternative, you have the right to waive a jury and have the case tried to a 3-judge panel. In this event, myself and 2 other judges would hear the case, decide the evidence, and if necessary, determine the sentence. The trial will be bifurcated, that is divided into 2 parts. 1 is the trial phase with either the jury or the 3-judge panel, and the second is the sentencing phase, which would happen if you have a jury or a 3-judge panel. Either way, there's still 2 phases to the trial. Okay, you understand?
The judge went over the possible sentences with Hinton if he is convicted.
If you are found guilty of the principal offense, but not guilty of the specification, I will sentence you to one of the following sentences: life imprisonment without possibility of parole, life imprisonment without parole for 30 years, life imprisonment without parole for 25 years, or life imprisonment without parole for 20 years. If you are found guilty of the principal offense and the specification, we will move to a second phase of the trial known as the sentencing phase.
So you hear the best case outcome that he has there is life with eligibility for parole at 20 years. That means you serve your guaranteed 20 years, and then you can possibly go to the parole board and, you know, make your case that you're reformed, or maybe you need a second chance in society. And maybe they give you a second chance, maybe they don't. Maybe say, all right, they'll give you parole, or maybe they decline you. So that within itself is like, you might just have me doing life regardless, whether I'm eligible for parole at 20 years or not. I don't remember. Let me pull this up real quick. I was gonna say, I don't know how old he is. How old is Rodney Hinton Jr.? How old is he? How old is he? Can we find it? You got it. How old he is? Okay, they got him at 38 years old. Okay. So if they happen, let's say he got that best case scenario, if he was found guilty, all right. I'm not here convicting the man, you know what I'm saying? But if he was found guilty and he got that best case scenario that the judge just said, that would be life. But let's say he does get paroled in 20 years, 58 years old. 58 years old. Okay. 58 years old. You can go to the parole. I don't know the frequency of how fast you can go back and forth to the parole board. Is it yearly? Once you serve your first 20 years, is it every 5 years? Let's see if I could find that as well. How often can an inmate go to a parole board? Let's see if there's a general answer to that. It might change state for state. At least annually in certain states, it's saying. Okay, and I'm pretty sure stipulations in states will change that, as well as factors. Life sentence reconsiderations. Inmates serving life sentences are reconsidered for parole at regular intervals, not exceeding 8 years. So it's possible that within that range, like what if that's determined at your sentencing if you're found guilty? You're eligible for parole after 20 years, and you can come back to the parole board if every time you're denied at 3-year intervals, right? So it's tough. It's tough. At the end of the day, when you're 38 years old, a lot of people will consider even the 20 if he was getting parole at that point at the best case scenario, you know, could be the rest of your life, right? You just don't know how health and things are going to go for 20 years in prison. So it is a lot. It is a lot, and that's the best case for him
The sentencing phase is presided over by the same jury
if convicted.
or the same 3-judge panel that heard the trial. At this phase, the state has the burden of proving that aggravating circumstances are sufficient to outweigh the factors in mitigation. The aggravating circumstance in this case is that the offense was committed and that the victim, Larry Henderson, was a law enforcement officer, and you had reasonable cause to know or knew he was a law enforcement officer, and either at the time he engaged in his duties or it was your specific purpose to kill a law enforcement officer. The prosecution has a burden of going forward with evidence that proves the aggravated circumstance. You have the burden of going forward with evidence of any factors in mitigation of the death penalty. Mitigating factors are those that lessen your moral culpability or diminish the appropriateness of the death penalty as a sentence. They can include your age, lack of prior criminal record, mental illness, etc. Just about anything can be a mitigating factor.
Now, after the judge went through all of these things with Rodney Hinton Jr., she asked him some other standard questions, and one had to deal with
Yeah, so even if the circumstances present death penalty because, let's say, you're convicted of killing a police officer, there are still things that could take that off the table. The person is 50 years old. We're not going to go for death penalty, or we're not going to exercise death penalty here, despite the person being convicted of a crime that carries death penalty. Mental state. All right, this person was tripping, wigging out. You know, that they didn't have all their marbles, whatever the case, temporary insanity. Maybe the defense goes for, maybe death penalty comes off. You know, so I understand what the judge is saying there. I feel like what person in a situation is even looking at that? Now, if he's in there like, I don't give a fuck about nothing because this was for my son, do what you do, then it doesn't matter, right? From his standpoint. But if he's in there and he's going to be fighting for his freedom, you know, whether they go the temporary insanity route, whether they go, you know, this was an accident, I didn't see the police officer, I lost control of the vehicle. I mean, we'll find that out pretty soon when, you know, when the trial begins. But I just don't see how the death penalty is first priority for him, right? Unless he's like, I don't give a fuck, this is for my son, so I don't care if I'm guilty or not. If he's trying to get out and he's trying to be freed, which I assume most people will, unless his mental is just that much gone behind the loss of his son, he's just like, I'm not hearing nothing. This is all just process to me. Whatever, put me in jail. Fuck y'all. Then death penalty or not, right? bugged out situation.
medications Hinton is taking.
Mr. Defendant, are you a citizen of the United States?
Yes.
And are you under the influence of alcohol or any drugs?
No.
Are you taking any medications right now?
Yes.
No?
Yes.
What medications are you taking, sir?
Oh,
Laxapro.
I'm sorry?
Laxapro.
I can't hear you.
Laxapro.
Maxiprone? Laxapro. And what is that for, sir? I'm just asking to make sure that he knows what he's doing today so that he's of clear mind. I ask all because he's entering his plea that he's not intoxicated, he's not loopy, he's not under the influence of any drugs. I'm not trying to pry into anything, sir, but just to make sure he knows what he's doing here today. So you don't think he's high on drugs, that he's competent to stand here today? That's all I'm asking, Mr. Bennett.
I don't think, I think you understand the nature of the procedure.
Lexapro is a drug used to treat both anxiety and depression. Hinton's attorney was difficult to
oh, whoa. You see, I was listening. I was like, wait, what is this? What is this drug that he says that he's taking? I heard Laxapro or something like that. In my mind, I was just thinking LA at the beginning of the word, laxative, possibly, right? A drug for emotional and what? Is the defense going to use that? Are they going to say that he was on that prescription or that drug prior to the situation or the incident? Whoa. That could be a big detail. Huge detail. Huge detail. Oh, shit. I wasn't expecting that.
here. But he said he believed that right now Hinton understood what was happening in court and that he was not intoxicated.
Then the plea is not guilty and will be entered as such. And anything else from the state?
Not guilty plea.
All right, thank you so much. Anything else from you, Mr. Bennett? I know that it's been a no bond hearing has been set and heard by Judge Yates, and the bond is currently no bond. Okay, anything further from anyone? Okay, I have a couple other further things that I want to say. All right, the defendant will be held and continue to be held without bond. Okay, I have a few more rights that I need to go over with you, Mr. Hinton. You have the right to have your case heard within a speedy amount of time.
Yeah, so we know the rest of that. I'll tell you right now, if they would have gave him a bond, he would make it. That money would come to him. It really would. Wow, I did not know that detail was coming. He's currently on a drug that treats emotional distress and anxiety. That's going to come up in trial.